Citizenship is supposed to be the finish line. For millions of immigrants, becoming a U.S. citizen represents safety, permanence, and finally exhaling after years of paperwork, waiting, and uncertainty. That's why the idea of denaturalization feels so shocking. In 2026, conversations around denaturalization are getting louder, not because citizenship is suddenly fragile for everyone, but because enforcement tools already on the books are being discussed more openly, reviewed more aggressively, and in some cases used more strategically. If you're a naturalized citizen or planning to become one, this matters to you. Not because panic is warranted, but because understanding the rules is the best protection you have. Denaturalization is not new. It has existed in U.S. law for more than a century. What feels new is the attention around it. When headlines say citizenship revoked, it triggers fear and confusion, especially online where nuance is often lost. So today, let's slow this down, strip away the hype, and talk clearly about what denaturalization actually is. What changes or policy discussions are happening as we head into 2026, who may realistically be at risk, and what warning signs to watch for. The goal here is not fear, but clarity. Denaturalization is the legal process by which the U.S. government revokes citizenship from someone who became a citizen through naturalization. It does not apply to people who were U.S. citizens at birth. It only applies to naturalized citizens, and even then, only under very specific circumstances. Importantly, denaturalization is not an administrative decision made quietly behind closed doors. It generally requires a court case, a high legal standard, and clear evidence. Under existing law, the government can seek denaturalization if it proves that citizenship was obtained illegally or by willful misrepresentation or concealment of a material fact. In plain language, that means either the person was never legally eligible for citizenship in the first place, or they lied or hid something important during the process that would have changed the outcome. As we move toward 2026, there are three main reasons denaturalization is back in the spotlight. First, immigration agencies are continuing long-term efforts to digitize and cross-check old records. Second, there is increased political focus on enforcement credibility, especially around fraud. Third, prosecutors are relying on existing tools rather than creating brand new laws. That distinction is important. For most people, there are no sweeping new denaturalization laws that suddenly change the rules overnight. Instead, what's changing is how existing rules are interpreted, prioritized, and enforced. One of the most talked about developments is the continued use of civil denaturalization cases rather than criminal ones. In a criminal case, the government must prove its case beyond a reasonable doubt. In a civil denaturalization case, the standard is lower, though still very high. The government must provide clear, convincing, and unequivocal evidence. This shift has raised concerns because civil cases do not require a jury and do not come with the same procedural protections as criminal trials. However, civil denaturalization has been part of the law for decades, and courts still treat it as an extraordinary remedy, not a routine one. Another area drawing attention is historical application errors. Many naturalized citizens worry that a mistake made years ago could suddenly come back to haunt them. The law distinguishes between innocent errors and material misrepresentations. A material misrepresentation is something that would have affected eligibility for citizenship. For example, forgetting to list a minor traffic ticket from decades ago is not the same as hiding a serious criminal conviction or prior deportation order. Context matters, intent matters, and materiality matters. Some denaturalization cases involve people who committed serious crimes before naturalization and deliberately concealed them. Others involve individuals who committed crimes after naturalization, but only if those crimes revealed that the person lied about their past during the application process. Post-naturalization crimes alone are not enough to revoke citizenship. That point cannot be emphasized enough. U.S. citizenship, once granted lawfully, is not revoked simply because someone later commits a crime. So, who is actually at risk? The first group includes individuals who obtained citizenship through fraud or intentional deception. This can include using false identities, hiding prior immigration violations, or concealing serious criminal history. These cases often involve extensive evidence and sometimes years of investigation. The second group includes individuals who were legally ineligible at the time they naturalized. This could involve failure to meet continuous residence requirements, unlawful permanent resident status, or disqualifying conduct that was not disclosed or was misunderstood. Again, the key issue is whether the government can prove that eligibility was lacking at the time citizenship was granted. A third category includes rare cases involving human rights violations, war crimes, or terrorism-related activity. These cases often involve international cooperation and are typically high profile. They do not reflect ordinary immigration cases and should not be confused with routine applications. It's also worth addressing a major misconception. Denaturalization is not used as a tool to target political opinions, social media posts, or lawful activism. Citizenship cannot be revoked because someone criticizes the government, participates in protests, or holds unpopular views. Free speech protections apply to citizens, including naturalized citizens. What about application mistakes? This is where reassurance is important. The immigration system is complex, and many people make minor errors without any intent to deceive. Courts have consistently recognized that honest mistakes, misunderstandings, or immaterial omissions do not justify denaturalization. The government must show that the error was deliberate and significant enough to have influenced the decision to grant citizenship. Real-world examples help clarify this. In some cases, individuals use different names or birth dates across applications to hide prior immigration violations. In others, applicants denied ever being arrested when they had been convicted of serious offenses abroad. These are not technical mistakes. They are intentional acts designed to bypass the law. Contrast that with someone who misunderstood how to list short international trips, misremembered an exact date, or failed to disclose an expunged minor offense they genuinely believed did not count. These situations are not the focus of denaturalization efforts. Another concern people raise is retroactive enforcement. Can the government apply new interpretations to old cases? Courts generally disfavor retroactive punishment. Denaturalization cases look at the law and eligibility standards that existed at the time citizenship was granted. While enforcement priorities may change, the legal framework does not shift arbitrarily. So, what are the warning signs someone should take seriously? Receiving official communication from immigration authorities, requesting clarification about past applications is one. Being contacted by federal investigators regarding prior immigration filings is another. Notices to appear in federal court related to citizenship status are rare, but obviously serious. Importantly, online rumors, social media posts, or secondhand stories are not warning signs. If someone is contacted by the government about their naturalization, the most important step is to seek qualified legal counsel. Immigration law is highly specialized, and denaturalization defense is even more so. Doing nothing, ignoring correspondence, or attempting to handle complex inquiries alone can make situations worse. For most naturalized citizens, the practical takeaway is simple. Keep copies of your immigration records. Be honest and consistent in any future applications or interactions with the government. If you discover an error in a past filing, consult an immigration attorney before taking action. Proactive guidance is far better than reactive panic. As we look toward 2026, it's also helpful to understand the broader context. Immigration policy in the United States often swings between periods of enforcement emphasis and reform focus. Denaturalization discussions tend to resurface during times when credibility and integrity of the system are being emphasized. That does not mean mass revocations are coming. Historically, denaturalization cases remain extremely rare compared to the millions of naturalized citizens living in the U.S. Citizenship is still one of the strongest legal statuses in the country. It provides protection, rights, and permanence that no other immigration status offers. The existence of denaturalization law does not negate that strength. Instead, it reflects the principle that citizenship must be obtained lawfully and honestly, just like any other legal status. Let's summarize what truly matters. Denaturalization applies only to naturalized citizens. It requires court action and strong evidence. It focuses on fraud, intentional deception, or lack of eligibility at the time citizenship was granted. Minor mistakes, lawful post-naturalization conduct, and political beliefs are not grounds for losing citizenship. The increased attention in 2026 is about enforcement of existing laws, not the creation of sweeping new powers. What should you do next? Stay informed from reliable sources. Avoid sensational headlines that thrive on fear rather than facts. Keep your immigration records organized. If you have concerns about past applications, speak with a qualified immigration attorney before assuming the worst. Knowledge and preparation are the strongest forms of protection. If you found this explanation helpful, make sure to subscribe to USA Immigration Explorer. We break down complex immigration topics calmly, clearly, and accurately, so you can make informed decisions without panic. Like the video, share it with someone who may need reassurance, and leave a comment with topics you'd like us to cover next. Immigration law doesn't have to feel overwhelming when you understand how it really works, and we'll keep helping you navigate it step by step.